If you are Haitian and living in the United States under temporary protected status right now, or if someone in your household depends on TPS to legally work and remain here, I need you to listen very carefully. Because 2026 is not just another calendar year, it is a review year, it is a decision year, and depending on how prepared you are, it could either feel like just another extension, or it could become a turning point that forces urgent, life-altering decisions. There is something I have noticed repeatedly in immigration cycles. When TPS gets extended, people relax, they breathe, they assume the pattern will continue. When rumors of termination start spreading, people panic. They start calling lawyers. They start asking questions they should have asked years earlier. Both reactions are emotional, neither reaction is strategic. Today we are going to replace emotion with strategy. I am going to explain how Haitian TPS decisions are actually made, what realistic scenarios could unfold in 2026, what risks are underestimated, what opportunities many people ignore, and what concrete actions you should take now while you still have legal protection. And there is one mindset shift that I will explain later in this video that could completely change how you approach TPS going forward. Stay with me. Let us begin with clarity. Temporary protected status was created as a humanitarian protection. It allows nationals of certain designated countries to live and work legally in the United States when conditions in their home country make safe return impossible. It is granted when there is armed conflict, environmental disaster, epidemic, or other extraordinary and temporary conditions. Haiti has received TPS designation multiple times due to political instability, gang violence, natural disasters, infrastructure collapse, and humanitarian crisis. Each designation or extension includes a specific expiration date. Before that date arrives, the Department of Homeland Security is required to review country conditions and decide whether to extend, redesignate, or terminate TPS. This review is where uncertainty begins. Here is something very important to understand. TPS is temporary by law. The statute does not promise permanent extension. It does not promise eventual adjustment. It does not guarantee conversion into a green card. It is designed to be temporary protection. That does not mean termination is guaranteed, but it does mean extension is never automatic. Now let us move to the core question. What will happen in 2026? To answer that, you need to understand the decision framework. When DHS reviews TPS for Haiti, they evaluate multiple sources of information. They analyze security reports, political stability, law enforcement capacity, humanitarian access, infrastructure stability, health system functionality, displacement levels, and the ability of the Haitian government to safely receive returning nationals. They also consider diplomatic relationships and broader immigration policy priorities at the federal level. TPS decisions are administrative decisions made within legal boundaries, but influenced by leadership priorities. That means politics does matter. But politics does not operate in isolation. Country conditions must legally justify the decision. Now I want to pause here and address something that many TPS holders misunderstand. An extension in 2026 does not mean long-term certainty. It means the clock resets. That is all. And this is where the biggest risk begins. Let me introduce you to two hypothetical TPS holders. The first is named Jean. Jean has been living in the United States under TPS for 12 years. He works legally. He pays taxes. He supports his children. He believes TPS has been extended multiple times, so it will continue indefinitely. He never files a family petition. He never consults an immigration attorney. He never reviews his entry history. He assumes stability will continue. Now imagine DHS announces that TPS will not be extended and provides a 12-month wind-down period. Jean now has 1 year to build a legal strategy he should have started building years earlier. His stress level skyrockets. His options are limited by time. Now consider Marie. Marie has also been here for 12 years under TPS, but she used that time differently. She consulted an immigration attorney. She filed an I-130 petition through her spouse. She maintained organized documentation. She evaluated whether she qualified for advanced parole. She understood her entry history. If TPS continues, she remains stable. If TPS changes, she already has a pending pathway. Same program, same years, different outcomes. The difference is not luck, it is preparation. Now let us discuss one of the most critical legal factors: how you entered the United States. If you originally entered lawfully with a visa and later fell out of status before receiving TPS, your options may look different from someone who entered without inspection. Lawful entry plays a significant role in adjustment of status eligibility. Some TPS holders have used advanced parole to travel and re-enter lawfully, which in certain cases has allowed them to create a lawful entry record. That lawful entry has sometimes enabled adjustment of status inside the United States if they had an approved family petition. But advanced parole is not risk-free. Travel policies can shift. Re-entry discretion exists. No one should travel without careful legal consultation, especially in uncertain policy climates. Now ask yourself honestly, do you know your entry history? Do you have documentation? Do you understand how that affects your future options? If the answer is no, that is the first thing you must fix. Let us move to another underestimated risk: criminal records. Immigration law treats certain criminal offenses very seriously. Even minor offenses can complicate TPS renewal or future green card applications. Some convictions can trigger inadmissibility grounds. Others can trigger deportability grounds. Maintaining a clean record is not just moral advice, it is legal protection. Now let us talk about employment authorization. TPS holders receive employment authorization documents. These cards expire. When DHS announces extension, they publish a Federal Register notice specifying re-registration windows and automatic EAD extension periods. Those notices control eligibility. Missing a re-registration deadline can jeopardize TPS. Filing late without proper justification can lead to denial. Relying on rumors instead of official notices is risky. When was the last time you checked your EAD expiration date? When was the last time you logged into your USCIS account? When was the last time you reviewed your I-797 approval notices? These administrative habits become critical in review years like 2026. Now let us address the political landscape. Immigration policy shifts with administrations. Some administrations prioritize humanitarian extensions. Others prioritize enforcement and stricter statutory interpretation. TPS decisions have historically reflected these shifts. In previous years, attempted TPS terminations were challenged in federal court. Injunctions delayed implementation. Litigation created uncertainty. But here is the hard truth. Litigation is not a strategy, it is a variable. You cannot build your family's future on the assumption that a lawsuit will protect you. Now we arrive at the most important strategic mindset shift in this entire discussion. TPS is a stability window. A stability window is a period during which you are legally protected and authorized to work. That window must be used intentionally. TPS should never be your long-term plan. It should be your short-term protection while you build something more permanent if eligible. Ask yourself these questions carefully. Do you have a U.S. citizen spouse? Do you have a lawful permanent resident spouse? Do you have a U.S. citizen child who will eventually turn 21? Do you have an employer who may sponsor you? Have you explored asylum if you qualify? Each of these questions represents potential pathways beyond TPS. Now let me tell you another realistic story. A TPS holder has a U.S. citizen child who is 18. The parent assumes that when the child turns 21, everything will automatically be fixed. But the parent entered without inspection and never traveled on advanced parole. Adjustment of status inside the United States may not be available. Consular processing may require leaving the country. That departure could trigger unlawful presence bars. Suddenly, what seems simple becomes legally complex. If that parent had understood entry law years earlier, they could have structured their strategy differently. This is why knowledge now matters more than speculation about 2026. Now let us examine Haiti's conditions. Haiti continues to experience severe instability in many regions. Gang control, political fragmentation, infrastructure collapse, displacement, and humanitarian crises are widely documented. These realities have historically supported TPS extensions. However, the question is not simply whether conditions are bad. The question is how DHS legally interprets those conditions under the TPS statute, and how leadership frames the analysis. Even if conditions remain severe, policy interpretation can vary. Now imagine two possible announcements in 2026. Announcement 1. Haitian TPS is extended again for another period. Those who prepared feel relief, but continue building long-term pathways. Announcement 2. DHS announces review with possible termination and a phase-out period. Those who prepared feel cautious but empowered because they have already built alternative plans. Preparation reduces fear. Let us talk about finances. TPS re-registration and EAD renewal involve filing fees. Budgeting for these costs prevents last-minute stress. Consistent tax filing strengthens your immigration record. Filing taxes accurately demonstrates presence and responsibility. Do you have copies of your tax returns? Do you have copies of every TPS approval notice? Are your documents organized? Organization is not optional, it is protection. Now I want to address something emotional. Many TPS holders have lived in the United States for more than a decade. Children were born here. Careers were built here. Churches, schools, and communities became home. The thought of instability creates anxiety. But anxiety without action creates paralysis. Clarity creates movement. Let us recap calmly. Haitian TPS holders are currently protected. Future decisions depend on DHS country condition reviews and leadership priorities. Re-registration windows are strict. Adjustment options depend on entry history and family relationships. Rumors are not policy. Preparation is power. You cannot control DHS decisions. You cannot control election results. You cannot control federal court rulings. But you can control documentation, consultation, strategy, and awareness. TPS is a shield. While you hold the shield, build your bridge. Do not wait for the shield to weaken before searching for the bridge. If this comprehensive breakdown helped you understand Haitian TPS 2026 more strategically, subscribe and turn on notifications. Share this with someone who needs clarity instead of panic. Preparation is power. Organization is protection. Strategy is stability. And we will continue monitoring every official development that affects the Haitian community in 2026 and beyond.